Can everybody hear me okay? Yes? Okay. So thank you everyone for being here. Again, my name is Melanie Oyama, and my topic is Association Non-Judicial Foreclosures. Basically what I'm going to be going over is the old non-judicial foreclosure law, the current non-judicial foreclosure law, the Intermediate Court of Appeals decision that interprets this new law, or the current law, what it means for associations, some of the impacts, and the pending legislation. So a brief overview of the old law under Chapter 667, which is the Non-Judicial Foreclosure Statute. There were two parts back in 2010. First part, or Part 1, had actually fewer consumer protections, and it was used if the mortgage contained a power of sale. The second part did contain more protections for homeowners, such as reasonable time and opportunity to cure the default and save the property from foreclosure. There are also varying notice requirements. In addition, the non-judicial foreclosure served as what they say a full satisfaction of the debt, meaning the association could not secure a judgment against the homeowner. And finally, another protection is that the conveyance document had to be signed by the homeowner. So as you can probably tell, it's a very difficult thing to achieve, if not impossible to achieve. So many associations did not conduct non-judicial foreclosures under Part 2. So on your outline, the second point is 3 cases that are ongoing that refer to Part 1. So this is the old law. So I'm not going to go into the details of these cases as far as Part 1 is concerned. But the names are there for you should you want to go and research further. What we really want to focus on this morning is the new law, or the current law as it stands now. So before I get into the lawsuit, here's a quick background. In June of 2012, Chapter 667 underwent significant changes and basically created Part 6, okay? So Part 6 is the association's alternate power of sale foreclosure process. What does that mean? It's another method of foreclosure. So basically you have judicial foreclosure and non-judicial. So this new law, as Part 6, gave you the alternate method, which is a non-judicial. So under Part 6, it did provide additional protections for homeowners, such as there is the recording of the notice of default and intent to foreclose. So there are requirements that come with that. One is it would provide the homeowner 30 days to submit a reasonable payment plan. So the statute defined reasonable payment plan is repaying the delinquency within 12 months, in addition to paying the current common assessments. Now, if a homeowner did request a reasonable payment plan, the statute stated that the association shall not reject it. In other words, the association, through their board, had no choice. Okay? In addition, another protection was it gave the homeowner 60 days to cure the default, meaning it gave the homeowner 60 days to pay in full. So, in addition, there was also what you call the public notice of public sale, and there was requirements that go with that. When you published, how you published, but primarily I think that one of the protections was here's another opportunity for the homeowner to understand or know what's going on. So that notice would be mailed out to all interested parties, including the homeowner. It would also be posted on the property so that it gives notice to anybody going to that property. It also allowed the owner to come back within 3 business days of the auction to pay. Okay. And finally, some of the other requirements, or the last requirement, is when it came down to after the auction and recording the conveyance, meaning recording the deed to transfer title, it had to be done within 45 days. And this requirement results in the timely recording of the deed, which essentially cuts off the period in time in which the owner is responsible, and it makes the association responsible for the monthly common assessments. Now, in addition to that Chapter 667, which all those protections that I just laid out for you, the Condo Statute 514B and the Planned Community Association Statute 421J actually added an additional layer to those that I just mentioned, which was that the association may not use non-judicial foreclosure if the delinquency came from late fees, fines, penalties. If balance did come from any of those things, you had to go judicial. You had no choice. Okay, so in other words, you could only use the non-judicial foreclosure if the balance arose from common assessments. So now I'm going to get into the court case that interpreted the new law, as it stands, Part 6. Okay. That court case is Sakal versus the Association of Apartment Owners of Hawaiian Monarch. And basically, Sakal, the homeowner, filed a complaint seeking relief from the association for wrongful foreclosure. And there were some other counts or allegations in that, but we're going to focus on the wrongful foreclosure aspect. So in Sakal, the homeowner argued that the association did not have the authority to conduct a power of sale. They did not have the authority to use the non-judicial, either by contract, which is your governing documents, your declaration, or your bylaws, and that the association did not have the power to conduct the non-judicial by statute. So that was his argument. And basically, because he did not have, the association did not have the power to conduct it, it was a wrongful foreclosure. But now, on the other hand, you have the association who's saying that their bylaws provided the broad authority to conduct a non-judicial. And basically, it states that the bylaws provide the association with the broad authority to enforce a lien, and that the available remedies include a non-judicial power of sale foreclosure pursuant to 514A and 514B both. So what does that mean? Well, in the Hawaiian Monarch bylaws, it stated 514A-90 specifically. So if your bylaws contain a reference to a statute, you have to go to that statute to see what it says, okay? So I'm going to read you part of 514A-90, and that states that the lien of the association may be foreclosed by non-judicial or power of sale foreclosure procedures set forth in Chapter 667. So hopefully I haven't lost you yet. So the association's bylaws contain the broad authority to foreclose pursuant to 514A-90. We go to 514A-90. 514A-90 states that you can conduct a non-judicial foreclosure. Okay. So I think I basically, if you recall, just a few minutes ago, I had stated that there was an extra layer of protection. So both Chapter 667, the non-judicial, and your condo and planned community associations all pretty much state that you can only use the non-judicial if that balance arose from delinquent common assessments. Nothing else. No late fees, no legal fees, no fines. So both 514, now you might be wondering about 514B because that's what's in play right now. 514B 146 and 421J-10.5 both have the exact same language, both for the power to do a non-judicial and that you can only use it for delinquencies from common assessments. Okay. So now I'm going to go into the court's review of this case and the facts and the conclusions that it's reached. So primarily, the court seemed to focus on the title of Chapter 667. And if you recall, alternate power of sale foreclosure process. That is what the court focused on, the word process. The court concluded that this title or this section only provided the process in which to follow. It does not and did not confer the power or the authority to conduct a non-judicial foreclosure. So that was what the court was looking at. And I'm going to state in their words, the court said, after an exhaustive review, we have concluded that over a number of years, the legislature has worked to craft workable non-judicial foreclosure procedures available to associations, but at no point did the legislature take up the issue of whether to enact a blanket grant of power of sale over all condo properties in Hawaii. Accordingly, the court went on to conclude that a power of sale in favor of the association must otherwise exist in the bylaws or governing docs or another enforceable agreement with the unit owners. So essentially, you need something in your project documents, not the statute. Okay. Now, on the other hand, you have your proponents of the non-judicial foreclosure statute, of course, would disagree with the court's conclusion and would argue that it is, in fact, the legislature's intent to grant a power of sale when Part 6 was actually created and when it was enacted. So now if you look, and my outline should still follow so far, there's example of power of sale provisions. I'm calling these the buzzwords. Okay? I'm not going to read it verbatim, but you can look for the underlying portions. Those are your buzzwords that the court would be looking at to see whether or not you have the power or the authority to use the non-judicial. buzzwords under power of sale, non-judicial, those types, or power of sale pursuant to Chapter 667. Those are some of the buzzwords you're looking at to see whether or not your project documents contain it. So essentially, right now, the Sakal case is the law of the land. So you might be asking yourself, why did I just go point by point with the arguments and the court's conclusions? Well, my understanding is, from what I'm doing here today, is I'm presenting you with the information. And it's about informing all of you as owners to better enable you to stay on top of the legal changes that will better serve your community. You stay involved, be involved with your board, be involved with your owners, so you have the most recent information. So what does the Sakal case mean for your association? Well, as like I said, if you have those buzzwords in your project documents, then the association can utilize a non-judicial foreclosure. Now, it doesn't matter if you're a condo or a planned community association. If your project docs do not contain those buzzwords or the necessary language that the court looked at, then the board and your owners, all of you, to come together to decide whether or not you want to consider amending the project document to include it. But remember, it takes owner approval to amend the project documents. So you as owners have a say in this. Now, if the project documents do not contain it, and let's say the board doesn't want to, the homeowners don't want to, that's fine. You just cannot utilize non-judicial foreclosure. But again, as a community, come together to figure out what's in the best interest of your community, what's in the best interest of your association. Basically, it comes down to change the documents or not change the documents. That's the question for all of you. So, as I move on my outline, Point 10, I just want to mention from this point on, it does vary. There was a lot that happened over the last few weeks after these went to print, so it's not going to follow as closely. So the impacts on the association who cannot utilize the non-judicial foreclosures. So before I get into the impacts, keep in mind that associations are zero-sum or zero-based budgeting. What is that? It's the method that the association determines what expenses that they're going to have to put out and how much is that going to cost. Where does that money come from? That money comes from common expense payments. Okay? So there's not income. Your associations are non-profit. They don't have income coming in to pay the expenses. So with that said, the only foreclosure option is a judicial. And it's not to say that there are not other methods of collecting, but if it becomes necessary to foreclose, and judicial is your only option because your project documents do not contain the necessary language, then associations are going to have to budget for an increase in legal fees because judicial foreclosures are substantially more expensive. Also, it will take associations a lot longer to recover the delinquency because judicial foreclosures take substantially longer than a non-judicial foreclosure. This is going to be putting a bigger strain on the association's finances. The association as a whole, meaning all owners, may end up paying more in your common assessments to cover the delinquency of non-paying owners. So why is that? Well, let's consider some additional impacts. First, and I'm not going to get into the details of the insurance, I'll leave that to Sue, our insurance guru, but first, there are some insurance carriers that are specifically excluding coverage for foreclosures, okay? Also, you have to keep in mind that insurance premiums for associations will increase if it hasn't already increased. Where do insurance premiums come from? Payment of common assessments. Let's take, for example, if there was a claim made for wrongful foreclosure and the association has to pay out as an uninsured claim. What do you do if the association does not have funds to pay those claims? You may have to special assess all other owners. You may have to take out a loan. In either case, it's going to impact all owners. This actually could potentially turn paying owners into non-paying owners. Because what if they don't have the funds to do the increase? What if they don't have the funds to pay the special assessment? It's going to have an impact on everyone. So pending legislation, SB 551, went through some changes. Again, your outline is no longer up to date, but essentially where it's at right now is that you can conduct the power of sale or non-judicial if it's contained in your project documents. There may be an establishment of an association foreclosure task force that will review the state laws and protect both the interests of the associations and the unit owners. But the key part is that this particular language, a foreclosing association that acquired a unit through a non-judicial, using Part 6 now, starting from June 28th, 2012, and recall that's when I said this part got enacted, the association shall be liable for reasonable damages and attorney's fees. So all of the impacts that I just went over is a very real possibility. So to recap, budgets for association need to include an increase for legal fees for possible judicial foreclosures, higher insurance premiums, taking out a loan. So as you can see, that there is some financial impacts. And I do this just so you're aware of the pending legislation. It has not passed yet. So lastly, I'll leave you with this. Association living is a community of people. And as a community of people, if you stand divided, especially with this kind of topic, your community may fall. But if you stand together and you work together to come up with a balanced look and a balanced approach, your community will succeed. Thank you for your attention.